May it please the court, my name is Brian Corey. I represent the appellant in this particular matter. This case it really arises out of two different issues under the trial court, two errors. The position is that the court erred by applying a litigation privilege defense in a residential eviction case, and two, applying a standard of more specific statutes over less specific statutes without finding a conflict between the two statutes. In this particular case, judges, the issue becomes the delivery of notice. Residential eviction cases begin under Florida statute 56, specifically 56 sub 3. 56 sub 3 is a notice requirement before you can file an eviction case. The 3-day notice is required to be delivered to the tenant in a particular form. 8356 sub 4 lays out the specific methods of delivery. There are three and only three. One is to mail, two is to deliver, and three, if the tenant is not home, you thereafter have to leave a copy at the residency. There is a subsection 5, which deals with one issue. If there is money paid to the landlord during the 3-day period, what is the landlord to do with the money? He is to either return it, put it in the registry, or post a new 3-day notice as required. The word post is the first time where that appears. And that becomes the big issue for the trial court in this particular case. I believe the trial court misunderstood the word post. Subsection 4 informs subsection 5. It's not the other way around. 5 does not inform 4. In this particular case, because subsection 4 of 8356 sub 4 only has 3 methods, those 3 methods are the only ones that are authorized. It actually says in subsection 5 that if you receive money, you shall repost the 3-day notice. Well, if you had mailed the document, the 3-day notice, how could you repost under the current definition that the court applied in the underlying case? You can't. If you read subsection 4, it says you can deliver it by mail, and under subsection 5, you have to repost or remail that document. And that's the issue with the court. The court said, no, we take the larger version of posting. We take the posting of, you have to put it open and obvious for everyone to read on the front door.
The exercising of that notice is a condition in the statute in order to proceed with eviction, right? And so that's what starts the litigation proceedings. And that action is protected action, is it not?
It is not. The delivery of the notice to the homeowner or to the renter is the condition proceeding. The posting of the notice, the outward facing posting, which is what happened in this case.
And you're saying that violates 559.
Correct. So in this particular case, what the court said was, no, you're required to post the notice face out, open and obvious. You can have protected behavior in that you actually delivered the notice. It's protected. Same as you have in Echeverria, where they delivered the foreclosure notices by mail. But that was protected because the delivery was there and the content wasn't disclosed. The behavior complained about in this case is not the delivery. It is the disclosure of the confidential information.
Don't we have to find that what you're saying violates this particular statute first in order for it not to be covered under the litigation privilege?
You do not. You have to find in this particular case, I mean, broadly speaking, you can approach the litigation privilege 2 ways. The court can take the very narrow view and say, listen, litigation privilege was asserted on a motion to dismiss, and it shouldn't have been.
Okay, but answer this question for me. Does posting of the 3-day notice with the, the language outward, does that violate Chapter 80, the statute on the eviction on the 3-day notice?
Does it violate? It doesn't per se violate the statute. And I guess, and this is the word smithing that I think we get into trouble with. The statute requires delivery. It doesn't require posting.
Yeah, and that posting language, I went back to go find out how that developed, and that's apparently a 2013 amendment where that posting language, but it does refer back that what was happening in subsection 4 is posting, because I don't know how else you can reconcile it.
Well, and I think you have, what definition the court is to apply in this particular case. The question really becomes, do we take the definition that's informed by 4 and say posting encompasses only 3 things? mail, hand delivery, or leaving a copy if they're not present. Those are the only things that posting allows. And obviously in 5, if you have to repost, first time the word posting appears in the statute is 5, then you have to either remail it, hand deliver it, or relieve a copy there. So although there
You're
are,
not contending that posting violates the landlord-tenant statute.
I am not, I am saying it's like a Venn diagram.
So I think we're going off maybe on a tangent that is unnecessary for this case. As I understand it, your whole position is posting it face outward is the problem. It's not the act of posting.
Correct.
Okay. So one of the things that concern me is I don't see anywhere in the statute, in your complaint, that anyone saw this document.
Well, we're on a motion to dismiss, and that's the problem with these cases. On a motion to dismiss, we're not able to put forth affidavits or take depositions or anything else. If they want to assert litigation privilege, which is what they did,
You did not allege anyone saw that document.
we,
You just, if I remember correctly, you alleged someone might have seen that document because it was face outward.
absolutely, we allege that in the actual complaint, it may have been seen, but we're deprived of the opportunity to put forth any evidence. In the affirmative defense of
But
litigation privilege,
if you're trying to assert a violation of the protected statute, the fair debt, whatever language was, fair credit statute, I'm not looking at it, so now I'm drawing a blank. Don't you have to allege that someone actually saw it?
no, I didn't.
Constitute an obligation?
Absolutely.
So merely if a letter were prepared that doesn't have the required disclosure statement that this, to collect the debt, and that letter never gets delivered, would that be a violation of the statute?
Letters never delivered. And it depends, and on those limited facts, we don't know. Was it ever disclosed to
But I
somebody?
think that's to me is a relevant analogy, because if a lender prepares a letter and maybe even puts it in the post office box in an envelope, and the contents of the letter do not include the appropriate language about debt collection, and the letter goes back to the lender unopened, etc., is that a violation of the statute?
I don't think it's a violation of
So
55972.
delivery of the problematic language or the letter not containing the requisite language, that's the problem, if it's actually delivered.
But the behavior we complain about is not the delivery, it is the disclosure.
But disclosure requires someone to see it, doesn't it?
It does not. Under 55972 sub 5, it says to post it in a way that it would be publicly available. It doesn't require an actual person to walk by and say, I saw this.
Use that language?
The actual statute.
Posting where it's publicly available?
No, the statute basically says to make it publicly visible to the public.
So in this case, sort of my letter analogy, which I know is not a perfect analogy, if you put something up that could possibly be seen, but no one ever, it sounds like did a tree fall in the forest?
Yes.
No one ever sees it, or there's no evidence that might come forward and no allegation of evidence that might come forward. Your contention is that's still a violation of the statute?
It is. It is my contention that just the mere creation and delivery and disclosure of that document, even if no one else sees
You keep
it.
using the word disclosure, and disclosure implies that someone has seen it.
Yes, and in fairness, I'm trying to track the language of the statute where it talks about disclosure. And we have gotten to the question of whether or not,
Let me ask you one different question. Is there any case that supports the theory that you're writing under here?
there is no case that says that the landlord-tenant statute,
We don't even need to refer to that statute. Is there any case under the other statutes, 559 statute, that says it is merely enough to constitute disclosure by having a document that does something wrong? Is there any case that says simply having a document with that improper language or the absence of the hard language, that in and of itself violates the statute?
there is no case that we cite in our briefs to discuss that particular issue about the incorrect language is not contained in the briefs and isn't an issue for the court. The issue, and unfortunately, I wish I could say to you, I have one off the top of my head, but I just don't. The issue for the court is, can you avoid liability under 55972 by claiming privilege by that communication?
Well, can't you under 559.773, where the act isn't intentional or it's a bona fide error, and wouldn't it be considered a bona fide error here where someone is complying with the statute, with 83?
That would be a great defense to be raised, in a pleading and a motion to dismiss. It's not an appropriate position. But moreover, in this case, what we actually have is intentional disclosure. It's taped to the door face out. There's no mistake here. This is an intentional act.
The purpose, but don't we have to look at the purpose of the statute? It's to curb abusive and harassing behavior by creditors.
Absolutely. That's the whole
And
purpose.
so based on the complaint, the Four Corners, was there anything nefarious stated in the complaint that the creditor did to harass the plaintiff here?
Well, they taped it face out in paragraph 11 and 12 of our complaint. We lay it out.
So then, let me ask you this. What they laid out in the language on the notice, is there anything in the language of that notice that was not consistent with the statute? Any complaint that it was deficient in any way?
The notice,
Required language, because it has to be verbatim, basically.
we agree, the notice in itself it tracks the statute very closely.
Nothing outside of that would have been considered to be abusive or harassing to the plaintiff?
No, the actual content of the letter itself is not the basis of the violation of 55972 sub 3. It is the delivery and posting face out that is the aggrieved conduct by the appellee. As such,
Would that complaint be satisfied if somebody just took it aside and flipped it over and put a little tack add to it?
absolutely, and actually we raised the issue in our complaint. We say they could have done this. This is an intentional act of placing it face out. You have the tape in your hand. You already had to go to the door and knock to make sure they weren't there. And you're standing there. You could either tape it face in and protect their private personal information, tape it face in, or you can disclose their private confidential information and tape it face out and run afoul of 55973 or 55972 sub 3. So in those issues, we believe that the landlord has a responsibility to protect their privacy rights. And it comes to this other question. At what point in time does the landlord get the right to disclose confidential personal information to the world?
Okay, so let me ask you this, how we're supposed to draw the line in this box, okay? So then you're saying the full notice can't be posted. Can an envelope that says eviction notice, that would violate the statute based on what you're arguing.
No, I don't know that it would. Well, if it says eviction
Eviction
notice,
notice, let's be honest, it's something you did wrong and it's negative to your reputation.
it could. Again, those are facts that
And
make,
these are things we have to think about in your argument because you're kind of encompassing all of that.
we are,
3-day notice, that would also seem to violate it too, because 3-day notice would imply that you were deficient on the rent.
the disclosure of the I owe this amount of money, you owe me $5,000 and it has to be paid within 3 days or we're going to evict you, is the facts that we have here. Can I envision a situation where you'd have less disclosure and still complain of these issues? Of course, that could be an issue, but that's a defense under 55973. We've never reached the issue under the facts we have here. We have an absolute bar to these cases, saying no matter what we do, that we actually can never bring these kinds of cases. This is the Sun case, and this is the Scott case, where it talks about the interpretation of litigation privilege eviscerating an entire cause of action. You could never have a person facing eviction complain of a violation of 55972. If the landlord came at 3 o'clock in the morning and rang the doorbell 400 times, saying I was delivering by hand to you, they'd say, well, it's privilege. We were delivering. We're in the statute. Or we make it a giant poster board and put it on their front door in red ink saying 3-day notice. We were attempting to serve the notice. There's no limiting principle if you allow litigation privilege to be an absolute bar to any of these claims. Whereas if you allow these claims to go forward and saying, was it litigation privilege or not? Let's have a determination whether privilege actually applied to the behavior. The behavior is not the delivery of the notice. It is the disclosure outward to the world. That's the problem. So can you envision a situation where the litigation privilege would impact the ability of any tenant throughout Florida to protect their confidential information and have the reputational harm not be affected?
And the cases focus on, like the defamation cases, focus on it being defamatory, the information being false.
Yes.
Anything here that's alleged in the complaint that the information in the 3-day notice was false?
And counsel, for your answer, you've got basically 4.5 minutes left, so I don't know if you want to reserve it.
I'll reserve the 4 minutes.
So why don't you answer Judge Smith's question, and then I'll reserve you the 4 minutes.
The cases that we cite, some of them do that, Judge, but I would direct the court to the case of Scott versus Albertelli and Sun Life Assurance. Those cases stand for the proposition that other causes of action are there. In fact, the Scott versus Albertelli case is an FDCPA case saying litigation privilege does not apply in the FDCPA realm. Thank you.
May it please the court, my name is Jean Marie Henney, and I represent American Homes, the appellee in this appeal. This is an action filed pursuant to the Florida Consumer Collections Protection Act by a limited liability corporation, KAC. KAC is not a consumer nor a debtor. Rather, KAC has obtained assignments of claims from tenants from around the state and initiated multiple FCCPA claims challenging a landlord posting of a rent pursuant to 8356 facing outward. There are multiple appeals pending in this court, the 4th District and the 5th District, all raising this exact same issue. It's my understanding this is the first appeal to have reached this stage of oral argument. There are multiple questions, there are multiple issues involving the dismissal of these complaints. The issues raised in this particular case is whether the posting of the 3-day notice is required by 8356 entitles the defendant to an absolute immunity, and also whether the specific 3-day posting requirement prior to the commencement of the eviction action controls over the general provisions of 55972. There are also issues of failure to state a cause of action based on a failure to allege disclosure to a third party. And then there's also standing issues, which we do not have in this particular appeal, whether a limited liability corporation can be assigned a personal consumer debt collection issue. What this complaint alleged was that the landlord, American Homes, quote, posted a 3-day notice as required by statute when commencing an eviction action. This is classic litigation and privilege. It is absolute immunity must be afforded to any act occurring during the course of judicial proceeding, so long as the act has some relation to the proceeding. This includes necessarily preliminary actions. There is no allegation that there was false information. This was done with malicious intent, that they were doing anything other than required by statute.
Ms. Honey, you heard me ask the question earlier, but I want to go back to that. Under 55972, paragraph 5, it does have the language about disclosure, non-disclosure. In order to present a viable claim, and I understand this was done on a motion to dismiss, but doesn't there have to be disclosure?
There has to be an allegation that it was actually disclosed to someone other than the debtor or her family, information affecting the debtor's reputation. So there was no allegation that this was actually disclosed to someone other than a family member.
Was there any, when the court was hearing the argument on the motion to dismiss, which I think focused primarily on the litigation privilege, was there any discussion that is evident from our record regarding disclosure being a necessary allegation to avoid dismissal?
From what is included in this appellate record, it does not, it does not appear in this appellate record.
And for the same reason, we don't know if there was a request to amend in order to include an allegation of disclosure.
A request to amend the complaint
Yes.
to include an allegation. No, there was not. I know that.
There is this reference in the complaint, I think it's paragraph 12, defendant posted the 3-day notice in violation of Florida Consumer Collection Practice Act by posting the notice face out disclosing to the world that the tenant owed money affecting his reputation. There is that in the complaint. Is it your position that just disclosing to the world was just a blanket assertion that doesn't meet the disclosing element?
Right, yes, I would argue that that does not meet the closing element, partly because this is an assignment of a claim, so we don't have the actual debtor who is filing a complaint that said, you know, my neighbor saw this and my neighbor, now my reputation has been ruined because my neighbor saw this. So we don't know there's no sufficiently specific allegation of a fact that would indicate this was disclosed to a third person. To someone other than the debtor or a family member that had reason to know. But what the absolute immunity does, it protects a party from having to defend a lawsuit. And that is why this is an affirmative defense that is permitted to be subject to raised on a motion to dismiss based on the complaint if the affirmative defense clearly appears on the face of the complaint. And in this case, when the complaint alleges that a party does what is required by statute, then it is appropriate to dismiss the complaint based on the affirmative defense. There was talk about Delmonico in which there was a qualified immunity, and that qualified immunity is not relevant in the instant case because what was alleged is that the landlord was doing what is required by statute. Since the landlord was in the safeguards of the protection of balancing the rights of a reputation with the public interest in judicial proceedings, then the legislature has set up those safeguards, and the landlord was well within them when they complied specifically with what was in the statute. If this court found that what the landlord has to do is put the notice in an envelope and tape it to the door, then this court is rewriting 8356, which provides that the notice may be left, and then, as Judge Smith pointed out, later refers into Section 4 saying after posting, referring back to the leaving, then this would be rewriting the statute to say you can't leave it in a manner that posts it because it has to be secured or hidden and concealed in an envelope. The problem with that is the legislature reasonably has reason to require that it be posted in a manner that can be seen conspicuously because it is a protection for the tenant. It is not an eviction notice necessarily. It's saying, look, if you don't pay your rent or leave the premises, then you're going to be subject to an eviction notice. So it gives them, it's an opportunity, it was a protection for the tenants. And if you require that it be concealed and put in an envelope, then the tenant may never notice it, might consider it junk mail or whatever. Also, the way, this is a condition precedent to bringing an eviction action. So if you don't comply with this provision, then your action is dismissed. So the way to prove that you have done this is to post it, take a picture, and then you can proceed with your eviction proceeding as having complied with the condition precedent. So the legislature may very well have reasons why it has not said you cannot leave it on the door in a manner that's facing outward. The other reason that the motion to dismiss was granted is that the landlord complied with a specific statute for how you institute an eviction proceeding. It complied with the condition precedent. Now, the more general statute is 55972 that says you can't disclose this type of information.
Is it the more general statute? Because isn't the landlord tenant statute simply saying post, it's not saying how to post? Whereas 559 is saying you can't disclose. So in terms of what posting is, seems to be more specifically addressed by 559, that you shouldn't be disclosing to the public these problems.
Well, actually, the term post is not defined in chapter 83, if you look at the
Which
definition.
suggests that 559 is the more specific statute.
Well, which would suggest that the court would use the plain and ordinary meaning of post. And post is the plain and ordinary dictionary meaning is that it is displayed outward.
Although the statute itself talks about leaving a copy or delivering a copy, the primary statute doesn't talk about posting. It's just a later section of the statute that references reposting, correct?
Well, it's, yeah, so the, under 4, it says that delivering a true copy of, if the tenant is absent by leaving a copy thereof at the residence. But then in 5, it says if partial rent is accepted after posting. So it's a reference back. If posting was not permitted, it wouldn't say after posting. And then under 5.3, it says posted new 3-day notice. So the legislature is familiar with the other sections of the statutes. So if they wanted to say post in a manner or leave a copy in a manner that is not disclosed or is compliant with 55972, it could have done that.
Let me ask you this, back to the discussion that I had earlier about an envelope. If you leave an envelope posted and it says 3-day notice and has the tenant's name, is that compliance with the statute? Based on your definition of posting, if we were to find that posting is required in disclosure to the public, is that sufficient by leaving an envelope like that?
Well,
Or does posting require that the entire notice be posted?
I don't know about require, but permitted. So the landlord.
The reason I'm asking is because I'm trying to determine whether or not there was, based on the face of the statute and the face of 559, whether there indeed was a conflict, because that is one of the issues that's raised.
Right, well, there is a conflict because 8356 permits the posting.
Well, that's
The notice
if we find that posting requires the disclosure in the language outward.
Well, I don't know if you have to find it required, but I think you can certainly find that it permits because it requires delivery, but it permits delivery in different methods. So it permits delivery by leaving it on the door, and then it later refers to the posting on the door. So you can't say that the posting outward is not permitted if the statute specifically refers to the leaving. So, but I don't think you can necessarily say the leaving is required. It is permitted. And if it's permitted by statute, then the landlord was well within the statutory requirements and doing what a condition precedent. And if you look at the allegations in the complaint, they posted a 3-day notice as is required by statute. So there's no allegation in the complaint that they weren't doing what was required by 8356. So that triggers the absolute immunity and prevents and protects the landlord, multiple landlords, from facing, from defending lawsuits for doing what they are strictly statutorily required to do, down to what the words are that have to be in the
Is there a case out there that says you cannot deliver the notice in an envelope simply addressed to the property and stuck on the door or slid in through the mail slot?
No, there's no case that I know of that says that. So it's, the statute gives you options for how to do it.
We know what the statute requires to be in the notice, but I'm wondering, can a notice be delivered inside an envelope simply saying John Smith, tenant, 123 Main Street, Tampa, Florida, and stick it up on the door with a thumbtack? Does that violate the notice statute?
Does it violate the notice statute? I don't think that, I don't know if it would violate the notice
So
statute.
it seems like we know what a landlord can do.
Right,
And the question really is, what must a landlord do? And the landlord must deliver a notice, whether by mailing it or handing it or slipping it through the mailbox, if it's one of those old style doors with a mailbox in it, or posting it. I mean, all those are acceptable. So then the question becomes, under 559, is it improper if you're posting to have language not hidden by an envelope?
well, I can see an argument being made in an 8356 proceeding saying, look, you just left it on the door and it's required to be posted, and the common language for posting is facing out. And when I saw it, I just, thought it was junk mail, or, I get all these kinds of solicitations on my door. How did I know what it was? I just put it in a pile. So,
Is there anything that says, you've mentioned twice, posting outward is part of the definition of what posting is.
yes.
Is there anything specific that says that? I know it's become customary.
Well, I cited the case, there are actually criminal cases that have to do with the posting in order to be found criminally liable for posting or displaying certain information. The court said it wasn't defined in the criminal statute. And so you have to look at the common definition, looked up Webster Dictionary. It says displaying to the public to view. So in this case, we have the same thing. We don't have posting defined in the definition section of chapter 83. So you have to look at the dictionary definition, just the same as courts have in other cases when posting is defined. That's
Would it
displaying
make
out.
sense to post a no trespassing sign with the language facing inward as opposed to outward? Obviously, that's not a 559 question, but I think that's where the posting analysis comes from, is posting for trespassing or posting different things in different ways. It's to provide public notice.
Well, and I think that's exactly a perfect point here. The purpose is to provide, make sure you get notice to the tenant that's, look, you're behind on your rent. I'm giving you 3 days to fix this problem. This is for your protection. And if you don't have notice of it, then, you're not protected. So yes, I think the exact same analogy applies.
The difference in my example of offense is, you are in fact posting public, you are telling the public at large. Posting of a 3-day notice is designed to give information to the recipient, not necessarily to the public at large. The public at large doesn't need to know that this tenant is in violation of his lease.
Well, if the landlord is a person that is not actually, I mean, if the tenant that is, whose name's on the lease is not actually the person living there, so, posting could have the purpose of notifying anybody that's living in this residence, like, the person that signed this lease isn't paying the rent, you're going to be evicted in 3 days. So, I believe that the legislature, has a purpose for not requiring this to be done in a manner that is concealed.
So we've got about a minute left, and Judge Smith was about to ask a
Yeah,
question.
yeah, my question related to 559.773, where it talks about there'll be no liability, where it's not intentional or there's a bona fide error. And does the act of posting the notice pursuant to a statutory requirement fit within that provision of 559 that would provide for no liability in that instance?
Right, and we can view that from the complaint, because the complaint says that the landlord was only doing what was required by statute. There's no nefarious intent. I'm not saying they were doing it with malice, not saying they were doing it with, anything that would take it out of the absolute immunity that is afforded somebody doing exactly what is required by statute. So there wasn't an error, there was no false information in it. They were doing exactly what was required of them. And they're protected under both, 8356, absolute immunity, 559, 723. From the complaint, there's no way to get to where the tenants, or the assignee tenants trying to get.
Cindy, that takes care of your time. You got your 4 minutes for rebuttal.
Thank you, Your Honor. I'd just like to address some of the questions that I've heard from the panel. The first is, the question is whether or not the disclosure was actually made to a third party. That issue is never raised below. The court didn't make its decision based upon non-disclosure. They didn't raise the issue of non-disclosure. Had they raised the issue, an amended complaint could have had the alleged disclosure.
Require it?
It does not.
It doesn't require disclosure.
The statute requires there to be an allegation of disclosure or disclosure, which we make the allegation at 12 and 13 of the complaint. If that's
In the
disclosure,
entire world.
but if that's, assuming that's too broad of an allegation, and I would concede that, that's probably not the greatest way to draft. Had they complained, a motion for leave to amend could have been had. A dismissal would lead to amend in 10 days to make specific allegations could have been had. But the court never raised those issues ever. The court said litigation privilege protects them, and we have a specific statute that covers a general statute without ever finding conflict. And we keep coming back to this issue of post. The court is, and the panel's asked over and over post.
Okay, so why are they not in conflict?
Well, one, they have to have a finding of conflict. Two, you can easily comply with both. You can deliver under 8356 sub 4.
But if 83 requires posting, and if we interpret that in its common meaning to be disclosure, then are they not in conflict?
If the court were to accept a definition that requires outward disclosure, the court would do great harm to 8356 sub 4, which says you can mail. How can I have public disclosure if I'm allowed to mail it? I'm allowed to mail this notice. There's no public disclosure, but if the court says the definition requires outward posting, then I can never comply by mailing. If it requires outward posting for the public to see, hand delivery doesn't work. The only way that the definition of posting works is to say posting is only 3 things: mailing, hand delivery, or leaving a copy. The Florida Supreme Court has come down multiple times on the issue of litigation privilege, and it comes down to one issue. Was it necessary and preliminary to the action? Delivery of a 3-day notice is necessary and preliminary. Disclosure of the content is not necessary and preliminary. So you can have a delivery that doesn't disclose. But once you disclose, it's no longer necessary and preliminary.
Then how do you weigh that, what Ms. Henny said, as far as the importance of making sure that it is visible for the tenant to see Because the protection here is to put the tenant on notice, to make sure the tenant then acts accordingly and does what they need to do, depositing money, whatever.
Very, very simply put, one, there's no requirement of depositing money. The 3-day notice just says pay. But council makes an argument that really is of no effect. The obligation of the landlord is to deliver. If, as she said, we deliver an envelope to the front door, tape there that says, Mrs. Smith, please, please come see us about an important matter, and takes a picture of it, that shows the delivery. If the tenant chooses to ignore things taped to their front door or slip through the crack or mailed to them, that's on the tenant, not on the landlord. The landlord fulfilled all of its obligations under 8356 by delivering the item. I don't have to guarantee this person reads it. I mean, the same thing can be said. The notice is posted to the door by tape, and someone walks by and tears it off. Is the landlord now saying, I've now been deprived of my right to evict? No. I fulfilled my obligations by delivery. The idea that you can't put it in an envelope and tape it to the door or slip it through the crack and protect confidential information and disclosure at the same time complying with 8356 runs afoul of a whole host of cases that says the court has to read these statutes in harmony. And you can comply with 8356, non-disclosure, and delivery by simply turning the document over, taping it face in. Anything, any simple act.
Council, that takes us to the end of your time.
Thank you.
Thank you very much. The final case on today's oral argument is Faison with the Best Buy.